of the Subcommittee on International Human Rights. Today, pursuant to the motion adopted on October 27, 2020, we're beginning our study on the role of the Canadian Ombudsperson for Responsible Enterprise. And Mr. Reid, glad you found the link, and those are some of the transition panes. And I'd like to welcome our new clerk, Naiman Sugrue. And Naiman, welcome. And he's no stranger to this committee. Naiman Sugrue, the clerk, was the clerk of this committee back in 2017 to 2019. And some of the members that are here, some of the vets, probably Scott and Ikra and Anita and Jennifer, I know subbed a number of times, and others probably know Mr. Sugrue from being here. Now, as we get on to the meeting, just to ensure an orderly meeting, I'd encourage all participants to keep on mute with your microphones unless you're speaking. And also my regular kind of 30 seconds, when your time's coming to a close, I'll put that up. I'll also do it, so I'll do that for the members and also for the witnesses for your behalf. At the bottom of your screen, for those that have not used this platform, you'll see a globe, and on that globe, if you need interpretation services, English or French, please select the language of your choice. And also that we ask that please note that screen captures or photos are not permitted. And at this time, I'm going to have an opportunity to welcome our first guest of this first panel, and that's from the Office of the Canadian Ombudsperson for Responsible Enterprise, CORE, Sherry Meyerhofer. And Ombudsperson, you'll have 5 minutes for your opening statement, and then we'll move to members' questions. You may begin.
Thank you, Mr. Chair. Merci. And thanks to the members of the subcommittee for your invitation. I appreciate your interest in the work we do, and I'm eager to answer your questions. Notre bureau est le premier de genre au monde.
Our office is the first of its type in the world. I believe that Canadians should be proud of it, proud of our engagement to protect human rights abroad. We're known as CORE, the Ombudsman for Responsible Enterprise. Our mandate was to help Canadian enterprises working abroad in the sector of the garment sector, mining, gas and oil sectors. We are independent and transparent in our work. We make public reports. In addition, we have tools to do reviews, undertake investigations, and whenever necessary, we make recommendations to the Minister of International Trade.
Was announced by government in 2018. I was appointed to my role more than a year later. Our team is currently concluding what we consider our startup phase. We are working from a blank slate. We are the first of our kind in the world. That meant consulting widely. We engaged with more than 200 stakeholders. We developed and refined our operating procedures. We published policy briefs and statements. We listened to ensure we are building an office that will make a positive difference in the world. And now, this winter, we have arrived at an important time for our team and for our mission. In the coming weeks, we will be launching an online complaints portal. It's a way for people and communities to reach out to us. Anyone, anywhere in the world, at any time, will be able to lodge a complaint by computer, by phone, by online form, email, even by letter. The online portal is easy to use. When a complaint is filed, it can be done so anonymously. If there are people or communities who have an issue, they can make their voices heard, and we will respond. As with any new body or agency, the creation of CORE has prompted a lot of enthusiasm, but also a range of questions. On me pose souvent une question en particulier.
We are often asked this question: do you have the tools that are required to do your job? I want to be very clear in my answer.
Our office can make a real and positive difference now. We can respond to complaints and initiate reviews. We can engage in mediation and publish our findings. We can make recommendations for action and publicly issue follow-up reports on their implementation. In other words, we can help Canada promote and protect human rights. Full stop. I have tremendous pride in what CORE is doing. And great belief in our potential. We are eager to begin our investigative work. Canadians expect their companies to respect human rights no matter where they operate. The creation of our office represents another example of Canadian leadership on the international stage. Thank you, merci, and I look forward to our discussion.
Well, thank you, Ms. Meyerhofer. And now we are going to go to members for questions. We are going to commence with the Liberals, and we have Ms. O'Connell for 7 minutes.
Thank you, Mr. Chair. I think my computer might be a little bit slow tonight, or the broadband. So if I freeze, hopefully I don't. But I thank you for your presentation. I want to start off. I recognize that this is somewhat new, and it's great that the online complaint portal is beginning. But what have you designed in terms of how will you determine what complaints to investigate? I'm sure you will have many, but what's that threshold, or what's that protocol? What are kind of the key points that need to be hit to actually begin that investigation?
Thank you, Mr. Chair. We have developed through very broad consultation our operating procedures, which we have translated into French and Spanish. It's taken a good deal of time to consult and to make sure that all people have had a say and are comfortable with our procedures. Those procedures set out, it's quite detailed, and it's got in terms of time, but with respect to what we will hear, there's admissibility criteria. There are 3. Number 1, is it a Canadian company? So we have to determine whether it's a Canadian company. Has a human rights abuse, is there an alleged human rights abuse of an international human rights? And is it outside of Canada? So it has to be outside of Canada. It has to be a Canadian company, and it has to be a human rights abuse that is recognized internationally.
Thank you so much. And again, through the chair, a follow-up question. How will you determine a Canadian company in the sense of this globalized world? There are not very many borders anymore. I recognize the criteria around the industries that you're looking at, so that might be a little bit easier just in the sense of, head offices or where these companies maybe originated. But with aggressive taxation planning, companies can set up head offices or corporate headquarters around the world. So is there a broad definition to determine that, to kind of get away from, in this case, it's oversight, but we see it elsewhere, usually for, taxation purposes? Is there some thought that has been given, or consultations that were given to look into that to make sure there aren't loopholes?
Thank you, Mr. Chair. Yes, there's a broad definition of Canadian company in our Order in Council, which sets out our mandate. That definition will allow us, it's a Canadian company if it's formed in Canada in any way formed, doesn't have to be incorporated, in any way formed, or any company that is controlled by a Canadian company. and those that are controlled by that company. There's 3 levels and layers there. So we will have to apply a very strict protocol to how we determine that. And we have consulted broadly on that with stakeholders, and we are putting a process in place for those determinations, part of our operating procedures.
Thank you. And in terms of one of the processes you have, again, sorry, through the chair, you know, essentially one of the mechanisms is naming and shaming, to put it in those terms, if you determine there are findings. So is there a process where you don't always name and shame? I know I used to be on finance committee and we talked about some of the financial mechanisms around the world, and sometimes there are decisions not to name and shame, and that justification. So is there a protocol in place, or must you always provide kind of that type of report? And do you have some sort of annual reporting, you know, for the investigations or the procedures that you've done, let's say in the course of a year, something like that?
Thank you very much, Mr. Chair. Naming and shaming is part of publishing, and we are required to publish all the, you know, if we receive a complaint, we have to publish on it. The amount of information that we publish with respect to a complaint will depend on the situation. It'll depend on whether the situation was mediated between the company and the complainant, and whether the complainant and the company requested that certain information not be published. That's possible, but we will definitely publish that we received 10 complaints, that we reviewed, you know, 8, that that kind of information will be there. But we don't always have to name and shame. There's also part of our mandate where we advise companies and we promote the international business and human rights standards. We can do a lot of know and show. We can be very proactive to prevent the occurrence of human rights abuses by letting companies know what they ought to be doing to avoid that, so that's part of the opposite of name and blame. It's know and show.
Great. Do I have more time, Mr. Chair? But I also see Madame Gill's hand up.
minute.
I don't know if it's translation.
1 minute.
Okay.
Je vais faire un appel au règlement, s'il vous plaît. Monsieur le Président? Oui, merci. C'est vraiment pour...
No, the interpretation is working very well. It's just out of concern. Can you hear the interpretation?
I suggest we suspend for just a minute then.
Sorry, I could not hear you, Clerk.
Okay, thank you, Mr. Chair. I guess in terms of the industries you're looking at, will there be, again, you're in an infancy stage, will there be opportunities to review your mandate? Is there, in terms of maybe additional industries as your role grows, as the organization grows and the need? If I can maybe leave that as quickly as possible. Thank you so much.
Hold on. Thank you, Mr. Chair. Certainly, we're open to advancing our mandate and making a positive difference in the world. So we would be open to that eventuality. We would want to ensure, of course, that a clear framework is in place to guide any additional work, additional work that would be occur because of additions of sectors.
Thank you. And now we'll move to the Conservatives, Mr. Chu, for 7 minutes.
Thank you, Mr. Chair, and thank you to Witness for coming and talk to us. Madam Mayor Hofer, I have a question about your mandate, since you actually quickly touch on that. Do you believe the core mandate should be expanded to include sectors beyond those listed, the 3 that are listed? Do you think we should actually expand that? What's your view?
Yeah. Thank you, Mr. Chair. As stated, certainly we're open to advancing our mandate and making a positive difference in the world. If that were to be by adding sectors, we would be open to that discussion. We want a clear framework in place to guide the additional work. So yes.
Okay, thank you. Second question is, many federal government agencies are burdened with a workload that causes significant delays in fulfilling their core obligations. How will CORE work to establish and maintain a timeline for actions on cases and ensure accountability for deadlines?
Thank you, Mr. Chair. In our operating procedures, which we have spent a number of months consulting with our stakeholders, government stakeholders, civil society stakeholders, and industry stakeholders, we have timelines. And so there's timelines in terms of responding when a complaint comes in and various other timelines. So those are set out and we will adhere to our timelines. There is discretion in some of those timelines, particularly if we're working on an investigation.
Thank you. I'm interested in the amount of investigation work that you could be getting because you know, it's a new office, and you know, in the coming weeks you'll be commissioning the online portal, making it very accessible for people around the world, anytime, anywhere, as you said. Aren't we, like, your investigation or your vetting procedure and protocol must be quite stringent, because otherwise there will be so much work coming to CORE from around the world, and you know that it could be quite overwhelming sometimes.
Yes, Mr. Chair, that's very true. And so our operating procedures, you know, will require us to make sure that that's admissible. So that's the first triage it comes through. And then we will look at, as I said, we have different aspects to our mandate. We have an aspect to mediate, so we can look at mediating. We can do early prevention with companies, try to prevent things before they happen, intervene early so that we can do it. So not everything is an investigation. So there'll be a lot of determining when facts come in, how they be dealt with, and not all will be an investigation. With respect to investigations, we will have to look at and you know, limit that to the amount that we're able to do.
Excellent. Now, how do you plan to maintain a constant communication with stakeholders in the industry, you know, and to make sure that we can constantly raise the bar on international human rights, but at the same time, realistically, so that we are not disadvantaging, making Canadian companies actually at a disadvantage. There have been cases that Canadian companies were held to such a high standard that we had to actually leave the industry, leave the country, and other countries were able to get hold of the original business and in mining, whatever, and therefore the local people actually suffer in respect of human rights, their rights being respected. So how do we make sure that this is communicated, and also your procedure and protocol constantly updated and communicated?
Thank you, Mr. Chair. I've worked in the oil and gas industry for 17 years and know firsthand that what CORE is set up to do is good for business. As part of our mandate, we provide advice to companies. And again, that allows us to be preventative. We can provide advice that allows them to be preventative, and it'll also for early resolution. So what we're doing is good for companies, and we'll be assisting them to be able to do their work better.
Okay, let me focus on one specific area. What is CORE going to be doing to preemptively dissuade perceived foreign government interference in cases, acceptance reports and recommendations?
Well, number one, Mr. Chair, our focus is on the actions of specific Canadian companies. Our focus is on companies, not on countries, and engaging in a way that protects human and promotes human rights. So we're focused on companies. But for guidance on matters like this, if there's an issue with a foreign country, we are fortunate to be able to draw on a wide range of expertise from the PCO, from Global Affairs Canada, and from the Minister's Office. We will not be, we'll be drawing on that expertise.
The other area is how do you envision CORE's announced gender and diversity strategy being implemented, and what real impact would it have on the actions of CORE?
Yeah, so we've made our statement, which we consider to be very important, and now we will be integrating that into every aspect of our work, and so we'll be putting in place, just like our gender based strategy, we will be also doing a racial strategy.
I would imagine those strategy would also have to be in accordance to the local situation as well. Am I being correct, or are we just implementing Canadian standards on foreign locations as well?
Yeah, Mr. Chair, absolutely. We are operating procedures and all of our work will be contextualized with respect to the area that we're working in.
Thank you. And we'll be moving now to the block. Madame Gill for 7 minutes, please.
Thank you, Mr. Chair. This time it was me having the problems. Mrs. Meyerhoff, thank you very much for your testimony, because of course this is a subject that is important for Quebecers and for Canadians, and we're very proud to have businesses work abroad, but unfortunately in some cases we can agree that some events have occurred that have really tarnished the reputation of some companies. And I have a question. Your office has been running since 2018. Do you have any examples of cases that you are processing where you've done some mediation? I would dare to think that you try to defend human rights. Do you have any examples of cases, without necessarily naming them, that come to mind to you?
It's been 3 years since the government announced the idea of an ombudsperson, but we've actually, I've been in my role and been at work for a much shorter period of time. So we're the first of the kind in the world. No other country has tried to do this, so it's very exciting. We're working with a blank slate, and because Canada's reputation in the world is so strong and so important to Canadians, We knew we had to take the time to do this right. So apart from the logistical aspects of creating a new entity within the government, we knew it was essential to consult widely here in Canada and around the world. And as I mentioned before, we engaged 200 stakeholders, and we've done we've developed our operating and procedures and refined them. So to date, we have not received any complaints. We have not been open. We have been in the creation stage. And as I mentioned in my opening remarks, Mr. Chair, we will be launching our online portal. At that point, we will be receiving complaints, and we will be either mediating or doing reviews. So none to date.
Merci.
Thank you. I'm sorry, I can hear an echo and this gets me off track. I have another question. So this is something that we're setting up that's completely new, but Mrs. Meyerhoff, you said that at the outset that you feel that you have all of the required tools to do your job, but I would think that that this will be assessed based on the work that you've done. I'm not tied to, I'm talking about word tied to complaints. So it's difficult to say right now whether, in fact, you do have the right tool, since this is something that's entirely new. You haven't been able to do any evaluation of that type yet.
Thank you, Mr. Chair. When I say we have the tools that we need in our order and council, we have the ability to respond to complaints, initiate reviews, conduct investigations, either collaboratively or independently, engage in mediation, and make remedial and other recommendations and reports. So those are all the tools that we have. And I'm confident that we have what we need to launch our complaints portal now. Yes, down the road, once we do the investigations, we may find that that needs to change, and we may need to reevaluate at that time. So yes, that's correct. But we have the tools in our OIC to get started on this, and we will learn along the way.
Oui, donc je suis contente d'entendre juste.
I'm happy that to hear that it will be assessed. There are Canadian companies that are in Mexico rather, and so it shows to what extent the work is important from both the qualitative and quantitative viewpoint. The budget that you have to undertake this work, what exactly is the budget?
Thank you, Mr. Chair. We have resources available to us. We have a permanent budget, and we have money that comes off cycle. And to date, we've had enough resources to do the work we needed to get set up. We've made our case on resources and are going through the regular channels with that. That is in the government process right now. So in terms of budget, I will leave it to say that we've made our case on resources. We've had enough to date, and we're seeking it through proper channels. Oh.
You have 1 minute left. You're on mute, Madame Gill.
I'm sorry. I didn't think I was on mute. We talked about the budget, but my question was how many people work for CORE? I would like to know about the human resources that are currently working there.
Thank you, Mr. Chair. We currently we own 6 full-time positions, and those are filled. And we also have a number of secondees. So at the moment, I believe working full-time on this innovation, on the creation of CORE are 10.
Okay, thank you. Now we're going to move to the NDP and Ms. McPherson for 7 minutes.
Thank you, Mr. Chair, and I'd like to thank the witness. Thank you, Ms. Meyerhofer, for coming. I understand you've worked in Alberta, and so I welcome you to Alberta via my living room. I have a few questions for you, just in terms of what you've been able to accomplish since the CORE was, announced in 2018, of course, and then you were put in place in 2019. Now, in 2019, my understanding is that you would be given the ability to expand your mandate within 1 year. What happened? Why was that not possible for you to do that?
Mr. Chair, when I was put in place in 2019, in May, the minister at the time had indicated that he would be seeking my advice on the expansion of sectors. And as you know, there was a change in government, a change in ministers, and the minister has not sought my advice on that.
So 2 years in, we now have a situation where you haven't been able to undertake any investigations to date, and you have not been able to expand your mandate. Is that correct?
Mr. Chair, I would like to rephrase the question. Like we have been in preparation and creation stage. This is very necessary for a brand new office, and so it's not that we haven't been able to. We realize how important this is to get this right, so we've been taking the time to create it. So that's how I would respond to that. And with respect to the number of sectors, again, I think we're open to doing that. In the future.
And so when you were in your introductory comments, you spoke about the fact that the online portal is ready to be launched. So will that be launched in the next couple days, next week, next month? How soon until we will see that be live?
Yes, I'm using, Mr. Chair, in the coming weeks, and I'm not going to be giving a particular date. I work within a large organization, within the Government of Canada, and we have a number of technical matters that are still being put into place. Our operating procedures are completed, our consultations are over, but now we have all of those very technical aspects of getting this up and running.
And for me, I've worked in the field quite a lot. I've seen Canadian mining companies and some of the environmental degradation, the human rights abuses that have taken place. And one of my concerns is that having a portal is one thing, but how exactly are populations around the world learning about the portal where they can share this information?
Thank you, Mr. Chair.
Ms. Meyerhofer, did you not hear the question?
Yes, I did.
Can you respond?
Yes. Sorry, again with your question?
Sorry, I just asked how people around the world that are victims of violence from Canadian mining companies would actually tell you about that. How do they know about the online portal that has not been launched but will soon, within weeks, be launched?
Yes, thank you, Mr. Chair, for the question. Yes, we're well aware of the need to communicate the role and purpose of our office and the ways in which people can communicate to us. And we're spreading the word and raising awareness through various channels.
What are those various channels?
Yeah, we have the cooperation of government in spreading the word overseas, and we're planning to raise awareness to our many stakeholders. So we would be doing that through civil society organizations working overseas, trade commissions overseas, and other networks, United Nations networks overseas, our international partners.
Yeah. Now, one of the things that you talked about is the idea of, I know that in 2018, when the ombudsperson was announced, it was announced to great fanfare within the sector. Many of us were extremely excited because we were told that you would have the ability to compel testimony. That did not end up happening. You do not have that ability to compel testimony. What do you do if what is the plan for if you investigate a company and they are not cooperative and they are not interested in sharing their testimony, or they are not sharing or interested in sharing their evidence with you? what will your next step be in that case?
Yeah, so I mean, it's true that the court doesn't currently have the power to compel witnesses or documents, but our review powers are unique and they strengthen Canada's responsible business conduct mechanisms. And so we have, as I said before, a range of tools at our disposal, and we can initiate reviews and conduct investigations. If
they won't share their information, how do you do that?
There's other ways of getting information. And we will be conducting investigations. We will be gathering information from all sources. If they don't cooperate, it's to their detriment because we will be coming to a finding of fact based on the information that we collect.
So can you explain to me how this is different than what we've had in previous governments? You know, we had a corporate social responsibility counselor, we had at the NCP. How is this different? What can you do that other previous government couldn't do?
Yeah, thank you, Mr. Chair. So the CSR counselor was embedded within the Department of Global Affairs and International Trade, and there was a counselor and I believe one other employee. We have much larger human resource foundation. We are an ombuds office, and an ombuds office carries with it a number of internationally recognized attributes, one of being arm's length and independent from their department. So we have that. The NCP, it does mediations. But we can, okay, so they engage in mediation, but we can not only engage in mediation, we can undertake collaborative and independent fact finding. We're required to file public reports. Under our mandate, we have to file reports, and we're empowered to make recommendations to the minister regarding potential remedial measures. Remedial measures are what is under our order and counsel under the UN Guiding Principles on Business and Human Rights. We are guided by that. The NCP is under the OECD guidelines on, guidelines on multinational enterprises. So we have the additional with the remedial. So there is a lot more breadth there than what we've seen under the CSR counselor or under the NCP.
And would you say that you're an independent?
Thank you. That's your time, Ms. McPherson.
Okay,
thank you.
thank you.
Colleagues, we're going to be moving into a second round. It's going to be kind of a strict 2 minutes for each member to ask questions. And we're going to start with, so a strict 2 minutes before we move on to the next panel. We'll start with Ms. Vandenbeld from the Liberals for 2 minutes.
Thank you very much, and I want to thank you, Ms. Meyerhofer, for being here today. 10 years ago, I was working in the Democratic Republic of Congo, and I was working with women's groups there who were working on a statement, a declaration about sexual violence in DRC. And all of the women pointed to the mining sectors as the root cause, whether it was directly or whether it was indirectly because of the armed conflicts over resource-rich lands. How does, when you begin to do your intake, your online portal, but also in the advice that you give to companies, how do you anticipate that what you're doing is going to be different than what would have been available back in 2011 in terms of both directly when abuses are occurring by Canadian companies, but also in helping Canadian companies to see the warning signs and to be able to do the prevention needed to make sure that their activities don't result in indirect human rights abuses?
Thank you. Mr. Chair, as mentioned before, like we do have a lot of tools at our disposal, and half of them are preventative. That's the advice to companies. And we are, already we've been giving advice to companies on COVID and things to watch out for, like the do's and the don'ts of this. And so we'll be able to do those kind of things with respect to conflict areas going forward. That's the preventative side. Then there's working with them on mediation, to help them if something is bubbling up, but nothing's happened, that's early intervention. And then there's helping them to resolve an issue once it's started. So all of that is available.
And we got about 20 seconds, unless you want to make a statement. Okay, so thank you. We're going to move over to the Conservatives and Mr. Reid for the 2 minutes. Thank you.
Thank you, Mr. Chair. And thank you to our witness for being here today. Glad to have you with our subcommittee. You say you provide advice. What kind, and you refer to this by the term know and show, what kind of advice do you provide? How would this be useful either to those who are afraid of having their rights abused, or presumably to companies who are anxious to remain compliant with both international rules and with the rules that you set out?
Yeah, thank you, Mr. Chair. So there's many ways we can provide advice to companies. I think that for the greatest impact, we wouldn't be providing advice to individual companies. They have other resources to go to for individual advice. But the core would be looking at, for instance, I gave an example of COVID and what are the new strains on business that could end up resulting in human rights abuses, and pointing those out to companies and indicating that they should be aware of these pitfalls and what they can do to take action against it. So that's the kind of advice, and we would provide that advice on our website and very broadly to companies. We can do own initiated reviews. If we were to, which is one of the tools that I didn't mention, but we can initiate our own review, an Ombuds initiated review. And so that is something we can look at if there's a long, a systemic issue out there that all companies should need to, we can do an investigation in that and let companies know about it.
Right. The advice you're giving is not about rules that you've developed yourself, but rather you're providing advice about rules that come from elsewhere. I have to ask the obvious question: why not just go to those other sources rather than to you? What value added are you providing in that regard?
Yes, that's right. We can't make any new rules, and so absolutely, we're looking at the rules that already exist. We're an option. We're a non-judicial option available for companies. There are other places for them to go. Many companies will choose to use other sources for advice for particular things, but it may be that we, in some circumstances, would be the best place for them to come.
Thank you.
Thank you, and we'll move over to the block, and Madame Gill for 2 minutes, please.
Thank you, Mr. Chair. Ms. Meyerhofer, I listened to everything you said. Your mandate's broad. You give advice, you do mediation, you get complaints, and you're going to have an online portal. But I remember Mr. Carr, back in 2019, he had asked for a review on the best way for the Ombudsman to carry out investigation on human rights. And the report concluded that without having any coercive powers, that CORE couldn't be as effective or efficient as it should be. What do you think of that?
Thank you, Mr. Chair. Yes, well, CORE does not. You better go get it.
We can hear you. It's okay. I think everything's okay.
Oh, sorry. Sorry.
Okay.
1 second. Sorry, we're having a small technical issue here at my end, and the technician is just in. Okay, I think we're back. Can I hear?
Yeah, we can hear you fine.
Okay, now I can hear too. I lost you.
Okay.
Thank you.
Go ahead.
All right. I apologize.
For about 40 seconds.
Okay. Yes. So, yes, while CORE does not currently have the power to compel witnesses and documents, as I've mentioned, our review powers are unique, and they do strengthen Canada's responsible business conduct mechanisms. I'm confident, as I've said, that we have what we need to do our complaints portal now. Of course, down the road, that may change. And, we can reevaluate what we need at that time. And I'm open to that reevaluation and assessment.
Thank you. And now we'll move over to Ms. McPherson for 2 minutes to conclude this panel. Ms. McPherson.
Thank you, Mr. Chair. So Ms. Meyerhofer, I just want to clarify. I tabled a petition because people within the sector and people across the country were understandably outraged when the position, the core ombudsperson was announced, and you did not have the ability to compel testimony, and you did not have independence. Do you feel that you could do your job better if you had the ability to compel testimony, and if you were actually a truly independent office?
Thank you, Mr. Chair. I support any measure to improve human rights protection as part of responsible business conduct. And at the same time, as I've said, I'm confident I can do the job that I've been given with the mandate I've been given and make a real positive impact. Again, definitely open to having things, advancements in the future.
Well, and I guess one of the advancements we could look at, I mean, we know that we are developing a feminist international or foreign policy. We have a feminist international assistance policy. It feels to me like this position has an important role in terms of the Sustainable Development Goals, which we've also signed on to. All of those things call for equitable access to justice. And when you don't have the ability to compel testimony, when you don't have the ability to actually hold Canadian companies to account, that does make me quite worried, of course. The one last question I will ask of you, though, is in terms of human rights due diligence legislation, have you considered how you could make that mandatory as part of your mandate, and how you could in fact have that in place so that you could be holding companies accountable before they undertake human rights abuses, before there are environmental degradation?
In about 10 seconds.
Great, thank you, Mr. Chair. We support mandatory human rights due diligence. I support it. It's the right thing to do. The global's going that way. There need to be discussions how the Corps would take that on, but we're for it.
Thank you very much, Ms. Meyerhofer. Thank you for your testimony, your answers to the many questions. We appreciate it for our core study. And that will conclude that first panel. Our second panel, we have members to our role of the Canadian Ombudsperson for Responsible Enterprise. We got from the Canadian Network on Corporate Accountability, Miss Emily Dwyer. She's the coordinator there. And Emily, I believe, Miss Dwyer, you are already all mic'd up and ready to go. So 5 minutes, please, for your opening statement. Thank you.
Great. Good evening, everyone. Bonsoir à toutes et tous. Thank you very much for the invitation to be here and for your interest in studying this vital issue. I coordinate the Canadian Network on Corporate Accountability, the CNCA. We were formed in 2005. We bring together 39 organizations from diverse sectors across Canada who collectively represent the voices of millions of Canadians from coast to coast to coast. We are calling for urgent action by the Government of Canada to address human rights and environmental abuses by Canadian companies operating overseas. Our network was vital to the government's creation of the Canadian Ombudsperson for Responsible Enterprise. In 2016, we published model legislation that was based on years of engagement with impacted communities, extensive research, and vetted by subject matter experts. We engaged in good faith with the Government of Canada to help build a best-in-class model based on specific commitments critical to the future of the office's credibility. We stood with Minister Champagne when he made the announcement of the Corps in 2018. It is telling that today, Canadian civil society, human rights organizations, and labor unions are not standing up in support of this version of the Corps. To the contrary, we have had to issue warnings to impacted communities to approach this office with caution, if at all. We should be singing this office's praises, and there's a reason that we're not. For years, hundreds of thousands of Canadians, organizations from diverse sectors, and multiple United Nations bodies have called on Canada to implement effective mechanisms to prevent and remedy Canadian corporate human rights abuses overseas. The kinds of abuses we're talking about include threats, killings, bodily harm, gang rape, unsafe and exploitative working conditions, forced labor, failure to respect rights of Indigenous peoples and women, serious environmental damage. Instead of implementing effective mechanisms, Canada has relied on voluntary approaches providing advice to companies about the expectation that they respect human rights, sometimes offering mediation and mediation approaches like joint fact-finding. The experience with Canada's toothless mechanisms, the CSR Counselor's Office from 2009, Canada's national contact point for the OECD guidelines since 2000, demonstrates that this approach has not worked. When the CSR Counselor's Office was closed in 2018, it had not resolved a single case. Canada's NCP, which is still in operation today, has also failed to investigate, prevent, or remedy harm by Canadian companies operating overseas. When it comes to effectiveness, the version of the core that we see today is not materially different from these failed offices. Without independent investigatory powers, the core will equally be unfit for purpose. Investigatory powers are the foundation of an effective ombudsperson's office. They are upon which the rest of the office's functions depend. Key information that's crucial to investigations is often held exclusively by companies, and it will not be offered voluntarily. I would like to put clearly on the committee record that what I'm suggesting here is not a new ask, not a request to reform the core right before it opens its doors. It's a request to give effect to what the Government of Canada explicitly and publicly committed to in 2018. From the Government of Canada website at the time of that announcement, I quote, "The Government of Canada is committed to ensuring that the Ombudsperson has all the tools required to ensure compliance with information requests, including the compelling of witnesses and documents." It's also a request to give the core the absolute minimum powers needed to do its job, the power to compel documents and testimony. Powers of the Government of Canada's own external legal review, the McIsaac report, which was commissioned by Minister Carr in the spring of 2019, which I hope to table for this committee, confirms are needed and within the federal government's authority to mandate. That report concludes the federal government can provide the core with these powers and that the office's effectiveness would be compromised without them. It is urgent that communities and workers impacted by Canadian companies operating overseas have access to effective grievance mechanisms in Canada, particularly as there's often nowhere else for them to seek redress for harm. We hope and expect that the current study at this subcommittee will lead Canada to fulfill its commitments, honor Canada's international human rights obligations, and empower the core to independently investigate. I look forward to the opportunity to answer your questions, provide further information now.
Oh, right on time. Perfect. Thank you, Ms. Dwyer. And now we're going to move to members for questions, and we'll commence with Ms. Khalid from the Liberals for 7 minutes.
Thank you very much, Chair. I appreciate that, and thank you, Ms. Dwyer, for coming before us today. So you mentioned, that the objective that was anticipated by yourself and many others from this organization, from CORE, and other renditions of it in the past haven't been achieved. And obviously, this has been a quite a long-standing issue as we deal with Canadian corporations going abroad. What do you think are some of the challenges that the government faces in creating that kind of framework that you've advocated for in the past through the advisory body?
The challenges the government faces in terms of fulfilling its explicit commitments to give the office the basic minimum powers it needs to investigate. Is that what you're asking? In terms of I'm sorry if I didn't entirely understand the question.
I'm asking what, so this is, I'll repeat my question. You mentioned that what you had advocated for over the past number of years has not been fulfilled through what is the current operation and operating mechanism of CORE, as well as any past renditions of a similar kind of framework to address these issues that you've raised in the past. So what I'm wondering is, in your opinion, what are some of the challenges that the Government of Canada, no matter which government it is, what are some of those challenges that the government faces in fulfilling or providing specifically what you're asking for in terms of the mandate for an organization like CORE?
Mm-hmm. And I think it's somewhat difficult for me to answer in the place of government, but I can share with you my observations based on the years of engagement with government, both previous and current. The CNCA published model legislation that provided kind of a blueprint for this office. We commissioned and produced memos and legal memoranda, expert opinion. We helped facilitate.
Sorry, I'm going to cut you off there. I'm specifically asking, as a corporation goes out and performs whatever business it conducts in other states, other countries, specifically, what challenges does the government of Canada have in terms of is there a balance issue between industry, between Indigenous issues within the frameworks of other countries? Is it labor laws within other countries? Is it disputes with labor? What kind of specific challenges, in your opinion, would a government like the government of Canada have in establishing that framework with teeth, as you put it?
There is a global and international accountability gap when it comes to business and human rights, when it comes to holding companies accountable. Our international framework is based on the obligations of nation states and doesn't easily apply to corporations. Around the world, host countries where companies are operating sometimes don't have laws that protect human rights or the environment, or those laws aren't enforced vis-a-vis multinational companies. What is needed is for Canada to fill take its place in that international accountability triangle and look at holding companies accountable and ensuring communities have access to remedy here in Canada for the impacts of Canadian companies operating overseas. What is entirely within the Canadian government's authority is to require companies to respect human rights around the world, not simply to expect them to, but to require them, and to create mechanisms that ensure that impacted communities and workers have access to remedy in Canada.
Can you, for me, cite or give some examples of other organizations that possess the enforcement powers that you're looking for in CORE?
Yes. So the Canadian Ombudsperson for Responsible Enterprise, or CNCA's model legislation for an ombudsperson's office, was based on an examination of existing ombudsperson's offices across Canada. The powers to compel documents and testimony are the norm in these offices and in analogous offices. So things like the Privacy Commissioner, the Information Commissioner, et cetera.
My apologies, let me clarify. Is there an international framework or a framework that exists within another country, similar to Canada perhaps, that has a similar kind of office set up for corporate accountability?
No, Canada, when they announced the Canadian Ombudsperson for Responsible Enterprise, they announced that it would be the best in class, the first of its kind in the world. It actually isn't when you look at what we have right now. Because of the absence of those investigatory powers, it's actually quite dissimilar from the national contact point, where actually national contact points in other countries do investigate. So the CORE is, or kind of the idea of another example of this kind of body that can compel documents and testimony internationally does not exist. One point just to quickly clarify is that it is based on other Canadian offices where this is the norm, and the power to compel documents and testimony would be vis-a-vis the Canadian company or documents under their control, not applicable to the kind of overseas companies, et cetera.
Thank you very much.
Thank you. And now we're going to move to the Conservatives, Mr. Reid, for 7 minutes.
Thank you, Mr. Chair. Ms. Dwyer, in your response to Ms. Khalid's final question, it sounded to me like you were contradicting yourself. You said on the one hand, we aren't best in class. And you said other countries have investigatory powers in their parallel bodies. But then you also said that nobody has the ability to compel testimony or the turning over of documents. So maybe I misunderstood, but it sounds like there's a contradiction there. Could you clarify
Sorry,
that?
I can clarify. In Canada, ombudsperson's offices often, and it's commonplace to have the power to compel documents and testimony.
Right.
What I understood the question from MP Khalid to be was whether there was an international ombudsperson's office looking at business and human rights issues that had the power to compel documents and testimony. And that kind of example does not exist. Where I was clarifying was that the ombudsperson's office, the core that we have today, does not have those powers.
Right.
It has the power to offer mediation, to undertake reviews. It doesn't have robust powers to investigate like we're committed to in 2018.
Okay, that's very helpful. Thank you. You mentioned that you'd done draft legislation, your organization had done draft legislation and had some position papers. I wonder if after this meeting is over, you could just pass those on to our clerk, or else I guess I'm really asking the clerk to contact you to get access to those. That allows us to treat them as having been entered into testimony.
We'd be happy to do so.
Thank you. Yeah, that's very helpful. Yeah, you said you caution stakeholders to be careful regarding approaching the ombudsman, or ombudsperson, I should say. And it sounds to me like you think it's actually, in some cases, I assume for people who are outside of Canada, in some cases unsafe to do so. Perhaps I misunderstood you. Could you expand on that?
Whenever impacted communities, human rights defenders are launching an international complaint or speaking out against corporate abuse, they face the possibility of risks and retaliation. In an examination of 250 specific instances filed at at the national contact points around the world, in a study looking at complaints since 2006, it was documented that 25% of those cases, those bringing complaints faced retaliation for doing so, and over half of those retaliation cases were linked to mining, oil, and sector cases.
Was there, but if I might, sorry, if I just want to ask, I see your point very clearly. I'm just thinking, is there a security issue? Presumably the ombudsperson would not be turning this information over and would have a duty to anonymize the information. Is it the case that inadequate protections exist at this point for someone who's come forward? And if you don't mind, one more question about this. I think typically it won't be the exploited person. It'll be some form of human rights organization intermediary who'd be doing this. But anyway, what are the appropriate remedies to make sure that one can safely and confidently approach the ombudsperson's office? That should be an easy fix.
Well, sorry, and just in finishing my point around the risk of retaliation, what impacted communities, the assessment that they will need to be making in bringing a complaint to any office is, given the risk of retaliation, is there a possibility of reward? Is there a possibility of remedy? Is it worth the risk in bringing a complaint? And if, based on the experience that we have with very similar offices in the past, the CSR Counselor's Office, the National Contact Point, that didn't have the power to investigate, that didn't have the power to compel documents and testimony, that didn't have the power, that relied on companies voluntarily participating, the result there for impacted communities was no remedy, waste of time and resources, and often a situation where they were put in more of a risk after bringing a complaint than before they came. And our analysis is it is exactly the same that will happen with this office the way it is currently structured.
Right, right. Yeah, I think of the famous example of Eleanor Roosevelt traveling through Russia and being approached by a prisoner there who presumably would have faced retaliation for having spoken out to her, despite the fact that she was well-meaning. She had no capacity to help that situation. I wanted to ask you about some of the remedies that do exist through our securities rules. A publicly traded Canadian company, so a company that trades on a Canadian stock exchange, in order to issue new shares or float a bond issue, if it is working overseas in the mining sector, has to meet with certain performance standards. It has to, for example, ensure that it's achieving certain labor standards in conformity with the ILO's rules. It has to make sure that it conforms with certain environmental standards, such as the use of properly maintained tailing ponds, reforestation efforts appropriate to the environment that's in place in that area. And there are a number of other such standards. These are enforced by Canadian professionals who have professional standards to live up to. And if they don't report accurately, they'll lose their professional accreditations. They have a very strong interest in doing that. If those reports aren't filed with the securities commissions, then it's impossible to refinance that company, giving a very strong incentive to comply with the rules. Does this model, in your opinion, have any merit, and could it be expanded to cover some of the other areas that you're describing, such as, for example, Indigenous land claim issues, or perhaps, I'll let you answer that.
What's really needed is for the Government of Canada to act on its commitment to provide an office that can provide an oversight and investigation role, an independent arm's length body that has the powers to do so. The rules around reporting at securities commissioners, I don't have the report at my fingertips right now, so I don't want to try and quote on it, but I will send it to you afterwards around the evidence of lack of adequate reporting, even for those who even under those rules. The evidence is that Canadian companies continue to be implicated in serious abuses around the world, in every corner of the world.
Okay, I think I've got time for one more question. Thank you.
Very quick.
Very quick. Okay. Yeah, so you talked earlier about independent investigatory powers. Does that mean in your mind simply that's a synonym for power to compel testimony in the production of documents, or does that have some additional meaning?
20 seconds, please.
It is an absolutely fundamental element of independent investigatory powers for this kind of office to have the power to compel documents and testimony. There's often really key information that's in the hands of companies, and without the ability to require companies to provide those documents and testimony, it simply won't be part of the investigation, and the rest of the office will crumble. You can't make effective recommendations without information.
Thank you.
Thank you.
Yeah, we're moving to the block now, and we had Madame Gill, and I didn't see you slip in there, Monsieur Brunel Duceppe, for 7 minutes.
Oui, bonjour.
Yes, this is Mr. Brunel Duceppe. Good evening, everyone. Thank you for coming, Ms. Dwyer. Your activism and that of your colleagues is very admirable in the human rights sector. You have a good reputation, and I'd like to thank you for coming with us this evening. Mrs. Meyerhofer said that she was confident that she had enough authority and resources, and she said this just a few minutes ago, but there are fewer than 10 people in her office. Am I crazy in pointing this out? Because I did a little quick research here, and there are 200 companies. The interpreter points out the sound is not working. Did you hear the beginning of my sentence? You didn't hear anything up until now? I heard the beginning, yes, when I was congratulating you on your activism. Oh, you heard that. Good, super. So I'll congratulate you once again. Ms. Meyerhofer said that she was content, thought that she had enough resources and authority, and she said this just a few minutes ago, but there are fewer than 10 people working in her office. She didn't really specify what her budget was. So I did a little mini research, And I'm looking that in Mexico, there are 200 Canadian companies working there. So how can we hope to have enough resources to cover that? I think we also have to look at who is going to be using this office with the current authority that it has. Since 2014, the office of the CSR counselor and the national contact point had the same authority to do this type of work with the support of the Canadian government. The budget for an office, well, like that, it should be compared to the office of the commissioner, the privacy commissioner, the information commissioner, in order to get an idea of the number of employees that are required and the size of the budget. I think it's also important to say that with a budget like that, well, with the budget that the Ombudsman currently has, it's not surprising that 2 years after setting this organization up, no investigations have been conducted. There have been no requests for investigation, and that's not a good use of resources. Yes, you were talking about the power to investigate. This investigative power is essential. But how would that change things? If we had the power to really investigate, how would things change? I'm going to answer in English. No problem. We have simultaneous interpretation.
The power to investigate is absolutely fundamental to this position. If you look at what an ombudsperson does, it does not issue binding fines. It does not send anyone to jail. It does not make any findings of guilt. What it does is independently investigate the facts, make findings of fact to help determine what happened, who was involved, and how to prevent and remedy those harms. If you can't get at the basic underlying facts of the situation, you can't make public reports that make findings of fact. You can't make recommendations that are tailored to the facts of the situation to help prevent these things from happening in the future. And you can't adequately make recommendations for future law and policy reform to help prevent this or to adequately remedy. Without the power to investigate, the office is entirely dependent on companies under investigation, companies accused of serious human rights abuses, voluntarily sharing information that may implicate them in abuses. For impacted communities that our members have worked with for over a decade, they are looking for prevention of harm and remedy, to be sure, but they're also looking for acknowledgement of what they have suffered and a commitment for things to change in the future.
You have 30 seconds.
Madame.
Ms. Meyerhofer said that coercive powers would be good to have, but that the office will have an impact even without this type of power. She talked about the power of making recommendation. Do you think that's adequate? Do you think the current power is adequate?
Sorry, we're moving to, for the next round, we're moving to Ms. McPherson now for 7 minutes.
Thank you, Mr. Chair, and I think we can probably get to that answer. But I wanted to very quickly thank Ms. Dwyer for joining us today. It's incredibly important to hear your perspective, and I wanted to just walk through a bit of a timeline with you, if I may. So in 2015, we were told during the run-up to the election that this position would be put in place. Obviously, it's been decades that we've been asking for a core ombudsperson with the teeth and the ability to compel testimony and documents. 2018, we actually have the announcement from Minister Carr. We get an ombudsperson in 2019. Devastatingly disappointing because we know that they don't have the ability to do the job that they need to do. It's now 2021, almost 3 years have gone by, and there have been zero investigations. The ombudsperson spoke to us earlier today about how there was a deep need to consult. Do you think that is a reasonable timeline, considering the urgency of some of the human rights abuses that we've seen by Canadian mining companies abroad?
It is absolutely urgent for impacted communities and workers around the world to have access to an effective mechanism to help redress and remedy harms that they have suffered. As I mentioned before, they're really serious abuses. It is a shame on Canada's international reputation. We've had multiple United Nations bodies telling Canada that we're not living up to our International Human Rights Commission commitments because we don't have an independent body to investigate. Canada announced this in 2018. It received international attention, and it is dragging its feet and not fulfilling that commitment, while globally we're seeing great momentum towards imposing legislation that requires companies to prevent human rights abuses throughout their global operations and supply chains and provides them with access to remedy. So throughout Europe, seeing legislation in France, recently a commitment in Germany and at the European Commission around mandatory human rights due diligence legislation. The kinds of abuses people are suffering are severe. And we've had this office before when Ms. Meyerhofer was speaking about this office being new and that being the requirement to need to take all of this time to consult. What one really asks, what is new about it? If what it is more budget, why did the government not simply increase the budget of the CSR Counselor's Office or increase the budget of the National Contact Point if all it was going to do was create another voluntary dispute resolution mechanism that put people more at risk and didn't help advance Canada's international human rights obligations?
Well, and this is one of the things that I was going to ask you about. I mean, I have stood on the ground in Nicaragua and seen the results of Canadian mining companies poisoning aquifers. I have seen sick children from Canadian mining companies. I've listened to the attacks. It blows my mind that we still don't have this ombudsperson. And so I was going to ask you about Canadians' reputation and how it suffered, but I think you've addressed that. Why didn't we get the ombudsperson we were promised? Why isn't the government living up to the promise that they made to Canadians in 2015 and again in 2018? What happened?
What appears to be the case is that Canada announced an office that would be effective, and immediately the mining industry engaged in a lobby campaign to say that they would not support this.
So ultimately, in your opinion, the lobby of the mining companies got into the government and lobbied successfully to have any restrictions on their ability to do whatever they want around the world without the clear oversight in place.
It is clear in my mind that the government caved to mining industry pressure and gutted the office before it was even able to start.
speaking of getting the office, my colleague, Mr. Brunel Duceppe, asked you a question just a few moments ago about the ombudsperson speaking about how she did have the ability to do her job. She did have the ability to make an impact. I think you didn't get an opportunity to answer him, but I'd love to hear your answer on what you think she's able to accomplish in terms of her investigative powers.
I think it's telling that when you asked Ms. Meyerhofer how she could investigate, how she would respond if companies under investigation did not voluntarily provide information crucial to an investigation, that she was unable to answer that question. Because quite frankly, it does not seem that there is any detail on the most crucial and important function of an ombudsperson's office. In terms of what she can do without the power to investigate, it remains a primarily mediation-based approach, and the ability to undertake a review potentially without access to necessary information. How can you publish a report with your findings of an investigation if you don't have access to key information? You can at the end say, here are the allegations that I've heard, and I haven't been able to verify X, Y, Z because I haven't had access to the information that I need. It's also telling that other bodies and similar bodies in Canada, other ombudspersons' offices have the power to compel documents and testimony and have the power to search and seizure.
Mm-hmm.
You only have 15 seconds, Ms. McPherson. We're going to move to the second round now. And
well, I'll take my 15 seconds just to thank the member and to highlight once again how important it is that this work is done, and to highlight again that it is all well within the power of the government to implement this ombudsperson with the powers that they had promised. That's correct. Very quickly.
And now we'll move to the second round, and this will be a short round. It'll be 2 minutes, just like the previous witness. So 2 minutes for each member for questions. And we'll start with the Liberals. Ms. O'Connell for 2 minutes.
Thank you, Mr. Chair. Thank you, Ms. Dwyer, for being here. With only 2 minutes, I'll try to get right into it. The U.S., following up on Ms. Khalid's question, the U.S. was seen as a jurisdiction that had some success in this area, but they were using the Alien Tort Statute, which was an 18th century law, and it had been challenged in the Supreme Court and ultimately lost in the ability to actually pursue human rights claims on U.S. corporations. So given the legal challenges, if you've seen that the U.S. actually did have a law with cases where companies were held and had financial findings against them and individuals. And
Monsieur le Président, je pense qu'on a un petit problème de son là.
On a point of order, I think we're having sound problems here. So we need to suspend.
Like Mr. Brunel Duceppe. No, is it just you, Mr. Brunel Duceppe?
Non, c'est un problème de traduction.
No, it's a translation problem.
Who was getting interpretation? You were not getting interpretation?
On m'a dit dans l'oreille qu'il y avait un problème d'interprétation.
Apparently, I've heard that there's an interpretation problem. I just heard that the sound was not sufficiently good to provide interpretation.
Okay, you heard that from who? I didn't hear that.
Ben, je l'ai entendu de la traductrice.
It was the interpreter who said it, but for the time being.
Brunel Duceppe? I don't know. I didn't hear.
Oui, l'interprète me l'avait dit.
Yes, the interpreter said that.
Just clarify, are interpreters speaking to members about how they're getting the interpretation?
Yes, if the sound quality, either due to connection or due to the way the witness is speaking, is too poor for the interpreters to interpret, they will indicate that directly through the interpretation channel.
To the member.
So my suggestion to the witness would be to just speak a bit more slowly and a bit more clearly, and hopefully that will allow interpretation to keep up.
Okay, thank
Well,
you.
it was me. It
Thank you.
wasn't the witness.
Okay, and
So,
Ms. Dwyer will have, so you've got 1 minute, Ms. O'Connell. Ms. Dwyer, I did
sorry,
stop
my
the time.
question, sorry, I'd like to finish my question before being interrupted, but my question was in and around allowing if the US has been challenged and not able to implement the ability to compel outside of the court system, and even that isn't challenged. Can you point to anywhere around the world that has been able to compel this information, especially outside of a judicial setting?
The Alien Tort Statute decision had nothing to do with the compelling of documents and testimony. It had to do with interpretation of application to business and human rights. So just a quick piece to say that it's not related to the compelling of documents and testimony. In terms of the legitimacy of compelling documents and testimony, these are commonplace, normal practices. All of the provincial ombudsperson's offices in Canada, to my knowledge, have this power, and analogous offices across Canada do as well. One thing to note.
But sorry,
also,
just to interrupt there,
Yeah.
to go into another
Ms.
jurisdiction.
McConnell, yeah, we have to move to Mr. Chu now for 2 minutes.
Thank you, Mr. Chair. I actually do have a similar question as Ms. O'Connor's, and I'm interested to see how would the ideal situation be given that unlike other ombudsperson's office, the core actually would require, if we are to have full investigative power, we would have jurisdictional conflict with the host countries. For example, we would require to be the ability to compel document witnesses, etc. So I wonder how you would actually respond to that, Ms. Dwyer.
The power to compel documents and testimony is vis-a-vis the Canadian company, Canadians, and documents under Canadian control, which means an order for production or an order to provide testimony would not be applicable vis-a-vis a company, a kind of an overseas company or someone overseas.
Understood.
Yeah.
But to have a full investigation to see all sides of the pictures, you would require access, and therefore you need the power to compel documents and also witnesses from perhaps overseas in host countries. No?
You can enter into, the Government of Canada could, on our advice, have authorized the ombudsperson to enter into mutual legal assistance agreements and letters rogatory. You can do desk research, you can do site visits, etc. The power to compel documents and testimony would be vis-a-vis the companies in Canada, and which means that there are some circumstances in which an investigation would not be able to be completed if the information that's being looked for is being held exclusively overseas. But having the power to compel documents and testimony would go a very long, vis-a-vis Canadian companies, would go a very long way to getting that information.
Thank you.
Thank you. Now we're moving
Thank
into the
you.
block. Mr. Brunel Duceppe for 2 minutes.
Thank you. Mrs. Meyerhofer, she talked about an online portal for human abuses, but she wasn't able to talk about the ability to give broad scope to this. Perhaps you could give your opinion on how people will, what can they do if they want to denounce something?
You should be able to bring complaints in person, via email, via paper, via partner organizations, etc. Vas-y.
Est-ce que c'est pas là
Well, isn't this a flagrant problem? We talk about denouncing a lot, but if you don't manage to do it, then the agency won't be able to undertake an investigation. Isn't that where the problem is? Isn't the gateway the problem?
The CORE's web portal and how they're expecting to accept complaints. So I can't comment on it specifically. For now, our main concern is that even once you got through the admissibility stage, the office doesn't seem to have powers to really do anything meaningful to respond to impacted communities once they get there.
Do you have a message that you'd like to give out very quickly?
One of the points that I would really like to emphasize is that the Government of Canada's own research, own external legal review confirms that it's within the federal government's authority to grant the powers to compel documents and testimony, and that those are needed to be effective. I will table that.
Thank you,
report
Ms.
with
Dwyer.
the committee.
Thank you. We're moving now for 2 minutes to Ms. McPherson. Thank you.
Thank you, Mr. Chair. And again, thank you to the witness. This has been very, very interesting. One of the things that I have spent a lot of time working on is the Sustainable Development Goals prior to being elected. And we know Sustainable Development Goal number 16.3 is equal access to justice. We know 16.6 is the effective, accountable, and transparent institutions for that justice. Can you talk a little bit about what you would like to see with regards to this ombudsperson position? We talked with the ombudsperson earlier today about human rights due diligence legislation. We talked about what we'd like to see this ombudsperson have, the ability to compel. What could be accomplished? How could we possibly be achieving? What could we achieve if we had the expanded role for this position? If it had the ability to do what it could?
One would hope that an effective ombudsperson's office would have the confidence of impacted communities and workers to be able to come see and bring complaints and seek redress. That the ombudsperson's office would look into those cases, would be able to establish and see patterns of harm, patterns of concern, and make tailored recommendations not only to prevent harm, but also to remedy it, and recommendations to the Government of Canada to be able, in terms of law and policy reform in the future, so that there are not continuing complaints 10 and 15 years from now. In 2005, the Foreign Affairs Subcommittee studied this issue and made recommendations that have still not been implemented now. It has been an eons of time that impacted communities have been waiting for the Canadian government to do something meaningful. We finally got there in 2018, and it is a shame that that commitment is being rolled back now, and that once again, we're seeing that the Government of Canada is turning its back on impacted communities and workers who desperately need a place to go.
Thank you, Ms. Dwyer. Thank you very much for your testimony. This will conclude this panel, and to members, we will now suspend, and we will come back in camera. Thank you.